Good evening. My name is Izzy, and I would like to welcome you all to the Harris Law Firm's webinar series, Wiser Together. Tonight's webinar, we're going to be discussing spring break stress and overcoming co-parenting challenges when managing travel and school breaks. And we are incredibly grateful that you are all able to attend. As a member of the Colorado community for over 30 years, the Harris Law Firm's always tried to give back. This and future webinars are a free service that we provide to that community. Now, I'd like to introduce our presenter today, Mr. Peter Goldstein. Peter has been a licensed attorney in Colorado since 1983 and is currently a partner of the Harris Law Firm. Peter is passionate about fulfilling the oath as Colorado lawyers to use his knowledge of the law for the betterment of society, the improvement of the legal system, serving the community, and helping people in need. Without further ado, Peter, I'll turn it over to you.
Thank you very much, Izzy, and welcome, ladies and gentlemen. Thank you for joining us this afternoon or evening. And just know we recognize that parenting time issues and travel can be stressful. Hopefully, we can provide some tips here that will help you deal with some of that stress and maybe minimize it, although it's not always easy to do. So here's an overview of what we're going to talk about today. So first of all, let me see if I can get this to work. So we're going to talk about the key laws that may be applicable to the situation. We're going to provide some practical considerations and tips, hopefully that will be helpful to you, and then we'll have an opportunity for Q&A at the conclusion. So first, let's talk a little bit about the current situation in Colorado and trends that we're seeing in family law and the courts. So what we're seeing is that there's increased travel frequency since COVID, especially surpassing pre-pandemic levels. And we're seeing that the average American is expected to take 3 domestic trips in this year. And spending on that kind of thing is considerable. So it's not unusual for these issues to arise, traveling with children, and those can be a source of conflict, but not always. So hopefully, if you're more aware of the likelihood of travel and how to handle travel and confer with your spouse, we can come up with ways to minimize stress. So what are some applicable laws in Colorado? Well, first of all, you can go here to find the statutes that I'm going to be talking about and to take a look and read what the law actually says. Also, the Colorado courts recognize that a considerable number of litigants are pro se. That means that they are acting without counsel. And so the Colorado courts have gone to considerable lengths to provide forms for self-help. And the way I always find this, if you don't remember this website or you don't have a chance to write this website down, if you just Google Colorado Courts self-help and forms, or just Colorado Courts and self-help, you'll find this website that not only has forms that you can use for pretty much anything that you need to do or may need to do in the court system on your own, but also instructions on how to use those. And the forms can be downloaded, I believe, in Adobe format or also in Word format so that you can add information and use them to file on your own. Because one of the things about domestic relations matters or family law cases in Colorado courts is you're not required to have counsel. You can act on your own. It's just really a question of whether you feel like you have sufficient sophistication to read the law, read the forms, read the instructions, follow them. Otherwise, you may want to get counsel, and that's what we at Harris Law Firm do, is we provide that counsel. So let's talk a little bit about the statutes that you might want to be concerned with. These are the main statutes. They're all part of Title 14 and of the Colorado Revised Statutes. And these are statutes that deal with rights of children, what the courts are supposed to consider in making rulings, which is generally focusing on what is in the best interest of children. They have rules or statutes that prescribe the circumstances under which and how frequently you can seek to modify existing orders for parenting time, how to handle disputes regarding parenting time. That's presumes that there are orders in place for parenting time, and how to modify those if you're seeking to modify those, and also modifying custody or decision-making responsibility. These are the statutes that apply. And I won't go into the details of what exactly they say, but we'll talk about them a little bit. So keep in mind that when it comes to allocation of parenting time, courts, they like tests. And there's really two tests that they apply. One test is a question of whether there's endangerment of the children. If the children's well-being or physical, mental safety is not threatened, then the courts apply the test of what is in the best interest of the children. That's what statute 14-10-124 talks about. And it enumerates different elements that the court has to take into consideration when determining what is in the best interest of the children. And these, what judges are fond of saying, and I've heard judges actually say this, is one of the elements is what the parents want, but that's only one of the elements, and it's not of greater importance than any of these other elements, and therefore courts and judges may tell you, hey, I'm going to listen to what each of the parent wants in terms of what they think is in the best interest of the children, but I don't have to comply with what the parents want. And there's one particular judge I'm thinking of who's fond of lecturing the parents and saying, look, I'm a stranger. I don't know you. I don't know your kids, but I'm charged with deciding what's in your children's best interests. So if you don't want a stranger making decisions for you as to what's in the best interest of your children, it may be the best bet, the best situation for you is to reach an agreement with your spouse or former spouse as to what a parenting plan is, and so that it's not left up to a stranger, not left up to the judge. But these are the things the court has to consider. It will take into consideration what each parent thinks is in the best interest of his or her child. If the children are old enough to express their desire, the judge can consider that. But if the children aren't old enough, then generally the court's not going to hear from the parents what the child or children want. The judge is going to hear from someone appointed to speak on behalf of the child, whether that's a child and family investigator, whether that's a parental responsibility evaluator, or whether that's a therapist, or whether that's a child legal representative who's appointed by the court to be an attorney for the children and hear from them. But again, even if they're old enough to express their wishes, that doesn't, just like the parents' wishes, the court doesn't have to follow that, because the children may express their wishes and the court can say, yeah, I get that that's what a child or children want, but that doesn't mean it's in their best interest. As the arbiter of what is in their best interest, the court will decide. These other elements are also things that the court is charged with considering. But I often think that the last two are on this list are the most important. The ability to encourage a loving relationship between the children and the other parent, and the ability to place the interests of the children before one's own. Frequently, we see situation in which a parent thinks he or she is the best person to make decisions on behalf of the children, and apportion time or decide what's in the best interest of the children. And that may be true. You may be right if you're feeling that way, but research and data tends to show that if the parents are not endangering the safety or well-being of the children, children benefit from having both parents in their lives. That's the perspective the court is going to take. And so if you take the position, I'm the best one to be deciding things for these children, and I'm the best one to have the most time, and I'm the better parent, the court is likely, not always, but likely to consider that a decision you're making that is not putting the interests of the children before your own, not demonstrating an ability to foster a loving relationship between the children and another parent, and that can work against you. So it's just something to keep in mind. So the next thing judges want to see is since they're starting with the presumption, absent a showing of endangerment by a parent, something that is in danger of the safety or well-being of the children by a parent, the court's going to want to see evidence that the parents are acting in a way that encourages frequent and continuing contact with both parents. Because again, the research tends to show that children benefit from having both parents in their lives. And so the judge is going to want to see evidence of that. Are both parents participating? Now, if one parent chooses not to participate, the court's not likely to make that parent participate. And why would you want to make a parent participate who doesn't want to be a parent? That's not going to necessarily be healthy for the children. But the court's going to be looking for signs that that's happening and that one parent isn't interfering with the other parent's frequent and continuing contact. Courts want to see that the parents are sharing the rights and responsibilities of child rearing. Now, again, if one parent doesn't want to be part of that, that's a different issue. And the court can take that into consideration with regard to those elements we talked about before. What's in the best interest of the children? If a parent is not demonstrating an interest in being actively involved in his or her child's life, then the courts may say, hey, that's a reason to apportion parenting time in a different way or apportion parenting decision making in a different way. But I'm going to start as a judge with the presumption that both parents want to be and need to be involved in the children's lives. And again, as I pointed out before, this is one of the elements encouraging love and affection and contact between the children and both parents. The court's going to want to see that both parents are capable of and demonstrating an ability to do that because that is presumed to be in the best interest of the children. And it's written right into the statute 14-10-124. That's one of the elements that the court is supposed to consider and look for evidence of in apportioning parenting time. Now, options and practical considerations with regard to travel. One, it's important to plan ahead. If you are in a situation where parenting time has already been apportioned by the court and or by agreement of the parties, you want to make sure that you're looking at whatever the most current order and written agreement say, because violating an order or an order approving a written agreement can be deemed contempt and also a failure to place the interests of the children before one's own. What if there's no order or agreement? Well, then you want to behave in a way that takes into account that both parents have rights to parent, and you want to demonstrate cooperation in the best interests of the children to the extent that you can. Why would there be no order or agreement? Well, if there is no action filed for a divorce or to apportion parenting time, then there's not going to be an order or agreement, and there's going to be a presumption that both parents have the right to participate in decision making about their children, and both have the right to exercise parental rights. If you filed an action to dissolve the marriage or to apportion parental rights, but no order has been issued yet, again, there's a presumption that both parties have decision-making authority and both parties have the right to have parenting time. And if one parent is depriving the other party of parenting time or decision-making, particularly with regard to major decisions that require input of both parties or should have input from both parents, that could be evidence to be used against the parent who's depriving the other parent of parenting time. And that could be used as evidence to apportion parenting time and decision making in other than an equal fashion. So wherever possible, you should try to clarify and agree in writing, if possible, what your approach to parenting and decision making is going to be. Courts prefer that parents reach their own agreement and reduce it to writing as to how they're going to apportion decision making and parenting time, because as I pointed out at the beginning, if you don't agree on it in the midst of a divorce, then the court's going to decide for you, and it may not be in a fashion that makes the most sense for you and your children, coming from someone who doesn't know either of you or your children that well. So reducing it to writing is important. It avoids misunderstandings. It clarifies the rights of the parties. And that can be as detailed or vague as the parties mutually agree that it should be. If you think that there's a likelihood of misunderstanding, you may want to have it be more detailed. If you think that you're in a relationship where you can work things out without having specifics, you may want to have it more general. If there's a dispute or if the agreement is unclear, first and foremost, certainly makes sense to try to find the most reasonable interpretation. Why? Because if there's an order or an agreement, the court is going to decide or resolve that disagreement over the order or agreement. And if it lacks clarity, it's going to look for the most reasonable interpretation of the agreement and try not to favor one party over the other. Um, if you if you'd like to avoid the time and expense of going to court, uh, it always is best to negotiate. Why? Well, first of all, going to court is expensive. It tends to be a relatively slow process because courts have a tremendous number of cases that they're handling at any one given time, and they have to, unless there's a statute that says they have to decide a particular issue within a period of time, they may not decide the issue on your time frame. Generally, when motions are filed, the other party has 21 days to respond, then 7 days for the original movement to reply. Then the court can rule at its leisure, or it can schedule a hearing. That's a slow process. It is a costly process, so it takes time to get the result that you want. And also, what I would say is the outcome in all litigation is uncertain, no matter how right you think you are, or no matter how clear you might think that the order or agreement in place is. So if you're going to be waiting on the court to resolve a dispute, um, you may not get the result you want and get it as quickly as you might like. So that's why it's important to try to negotiate, trying to reach resolution, try and push for a resolution, try to attempt to clarify what each party's position is and what some alternatives might be for resolving disputes. um, Grandparents. So generally, grandparents are not part of a parenting time agreement. There are circumstances under which a grandparent can seek time, but one of the first questions we're going to ask is on whose parenting time, because if you have a parenting time agreement that allocates parenting time between the two parents, then generally during one particular parent's parenting time, he or she can decide who the children associate with during that parenting time, because each parent is allowed to parent in his or her own fashion during his or her own way, and as long as it doesn't endanger the children. And that means deciding who will babysit, whether they'll visit with, who they'll spend time with. And so if there's a question about whether grandparents will have parenting time, it may be that mother elects to have the maternal grandparents see the children during her parenting time, and the father allows his parents to see and the children's grandparents to see the kids during his parenting time. Um, if there are specific rights to parenting time, ordinarily that would be something you might specify in the parenting agreement. But if there's no parenting agreement, then it may be something you want to discuss between the two parties and try and reach an agreement in advance. Other potential areas of conflict. Who's going to supervise? Who's going to babysit? Generally, as I pointed out previously, during parenting time, during a particular parent's parenting time, he or she can decide how he will make decisions, day-to-day decisions that aren't major decisions. That major decisions tend to be medical decisions, medical treatment or care, where the children go to school, um, uh, things along those lines, where what kind of religious activities they'll engage in. But day-to-day decisions, such as who will supervise them and who will babysit, and if that's not addressed in the parenting agreement or parenting plan, then each parent's going to be able to make his or her own decisions about that, whether or not the children drive, whether or not they're supervised, and to what extent. Um, as far as overseas travel, that could be addressed in the parenting plan. That is generally something that's addressed in terms of who will keep the passports, how much contact there will be during travel time, whether they can travel overseas without permission of the other parent, and where they may or may not be permitted to travel to because some places overseas are dangerous. So those are things that are best to try and reach agreement on and put in the parenting plan. Again, day-to-day decisions that don't require intervention of the court and are not likely to require intervention of the court are going to be made by the parent who's during his or her parenting time. And so how much homework is done, when homework's done, where homework's done is going to be decided by the parent the children are with, unless it's otherwise specified in the parenting plan. And even if it were specified in the parenting plan, it would be kind of hard to enforce when if the parents are divorced and they're not there to see just exactly how that's handled. So two critical legal questions on travel specifics are, do any current orders or parenting plans that have been approved by the court resolve the issue? Always want to read and see, all right, if I'm going to engage in travel with my child during my parenting time, what do the current orders say I can and can't do? What are the limitations? Under what circumstances do I have to get the other parent's consent during my parenting time and comply with those orders as best as possible? Also, there may be agreements as to how frequently the children will communicate while they're traveling with the other parent, and also how much information has to be provided to the other parent in advance of that travel. Um, Even if consent isn't required, does the traveling parent have to notify the other parent of where you'll be staying with the children, and any changes to the itinerary? Does the itinerary have to be shown to the other parent? Those are the kinds of questions that you may want to, you should always consult if there's an agreement in place and an order in place to see, does it cover those things? And if there's no agreement or order in place yet, those are things that you may want to consider and talk about. Um, when I've talked about major decisions, those tend to be decisions like where the kids will go to school, what religion they may follow, what medical treatment that's not other than regular doctor's visits. That those are the kinds of major decisions that I'm talking about that generally require both parents to participate, unless there's an emergency. And even then, the parent handling that particular emergency during his or her parenting time should be consulting with the other parent and notifying the other parent, at least. So we've talked about what's day-to-day decision making. Day-to-day decision making tends to be the things that you would ordinarily decide on your own that aren't major decisions: what the children eat, what they wear, what they do with their time during your parenting time, who they associate with, who babysits them or handles their care when you're working. Um, Again, unless addressed in the parenting plan, those are things that generally each parent is allowed to do and decide. Um, Additional help. So if if you reach an impasse with a parent, with the other parent about care of the children or decisions that need to be made, um, there are parties who can help you. Parties can stipulate that there will be a what we call a PCDM or a DM, and that stands for parenting time coordinator or decision maker or people that serve in both capacities. Parties can stipulate that to somebody who will make decisions for them or resolve disputes. And that can be beneficial because it could be someone they go to who's vested with the authority to make decisions and get a court approval of those decisions later if necessary. But that can be useful because if parties agree on a parenting time coordinator or decision maker for major or less than major decisions, then they have someone they can go to that can decide things faster than a judge might, and hopefully at less expense. Yes, you'll pay for the parenting time or for the time of the parenting time coordinator or decision maker, and you would not have to pay for the judge to decide, but the benefit is you get decisions faster, and it may be less costly than paying attorneys because you don't have to have attorneys involved, and it may not take as long. CFIs are child and family investigators. Um, if you are involved in a dispute over allocation of parenting time, parties can stipulate to have a CFI, child and family investigator, appointed to investigate what's going on in each parent's home, what the children may be expressing an interest in having happen during their time with each parent, what their preferences are, and then that CFI can be prepared to make recommendations to the court, but also recommendations to the parties, because after all, generally when parents are separated or divorced, they don't know what's going on in each other's home. They don't know how the other parent is parenting, except for what they may hear from the children. And children can be influenced by their parents to say what they think the parent wants to hear. And so that's why the courts appoint, or parties can agree on, independent investigators like child and family investigators to investigate and make recommendations. Mediation is also an alternative for resolving disputes. And in fact, if you go to court over motions to modify parenting time or modify decision making, or even if you're just in the midst of a divorce where no orders are in place for those kinds of things, the court is generally going to require that you go to mediation regardless before you get a hearing. Sometimes before you even get temporary orders, but almost always before you go to permanent orders in your case, you're going to be required to go to a mediator. What's mediation? Mediation is a neutral third party, not associated with or related to either party. Can be an attorney, but doesn't have to be, who will work to help the parties reach a, a decision or agreement without court intervention. The mediator generally has no power to decide any issues, but simply works with each party, going back and forth, usually between parties in separate rooms, to get each party's perspective and solicit proposals for how they might resolve a dispute without court intervention. And then mediators often will reduce the agreement the parties reach, if they're able to reach one, to writing. Again, this can be done without attorneys involved. You don't have to have an attorney to go to mediation. You don't have to have your attorney join you in mediation. Um, you do pay for the mediator's time. Generally, the cost is shared equally between the parties. Therapists. I always think it's a good idea if you have people who have specialized knowledge of what may be happening with your child's health and well-being and can make recommendations, to have them weigh in, not only because if you're doing what's in your best interest of the children and you want to do what's in the best interest of your children, and you have somebody who knows more than you about their mental, physical well-being, who can make recommendations, not only are you more likely to do what's in your children's best interest, but it also may, to some extent, insulate you from accusations of having acted contrary to the best interest of the children, because you're following the advice of a therapist, assuming you can get one and assuming that you get good advice. Doesn't mean you always have to follow that advice or agree with it, but it may be helpful. Non-legal resources. So you can go to other people for advice, and they may help you see things from another perspective, including the other party's perspective, which can be helpful. Being able to see outside of what your own interests and desires are and see things from another party's perspective is a great idea. Also, these people can lend emotional support. I would just caution you about relying too much upon legal advice from these people, because these people may not have sufficient knowledge. They may be coming from experience that is different from your own, from their own divorce, where the circumstances may be very different. And obviously the parties are going to be different. And also they may be looking to tell you what you want to hear, especially if it's a family member or a friend, as opposed to helping you see things from another perspective. So I would always consider these kind of folks for emotional support, but not necessarily legal advice. Um, if all else fails, certainly it makes sense to look for opportunities to compromise, because even if you can only compromise on some things and not all things, that's one of the advantages of mediation is you don't have to settle every single aspect that's in dispute, but you can settle aspects of the things that are dispute and leave the remaining aspects or disputes for a court to resolve. You've saved yourself time and money right there. So compromise is always best if it's in the best interest of the children, and if you can avoid the sometimes slow and expensive process of going to litigation. Also, what mediators will tell you is that all outcomes in litigation are uncertain. You're almost never guaranteed of any particular outcome because courts, judges may believe some, all, or none of what you testify to. Similarly, they may believe some, all, or none of what the other party or other witnesses testify to. And so, as right as you may feel you are, and even if you may feel the facts are on your side, if the court doesn't agree with your version of the events, you may not get the outcome you want. And settlement tends to be the only way to get a certain outcome because it's the outcome you agree upon with the other party and that the court approves. That's going to become an order of the court if that occurs, versus going to court and to some extent rolling the dice. Examples of compromise, well, certainly a parenting plan that you agree on is an example of a compromise. Um, you may not get everything you want, but you can get some of what you want if each party makes if each party makes concessions and you get most of what you want. It's better than perhaps rolling the dice and going to court and not getting the outcome you want. Um, that's something that you can compromise over. Taking the high road is always a great idea. One of the things that people tend to sometimes forget in the midst of divorce is that depending on the ages of your children, you may be dealing with the other party, the other parent, for a very long time. Your relationship isn't going to end when the divorce decree enters, because if your children are, say, 4 years old, and you're going to be making decisions with the other parent together with them for the next 14, 15 years. And then still, even after that, going to major life events like weddings together, at least during the time that your children are minors, you're going to be making decisions together. And so if you can be positive in making those decisions and keep the interests of the children in your mind in the forefront, that's going to be advantageous for you. It's also going to be advantageous for your children because conflict does harm children. There's studies that show that the more conflict there is between the parents, the more it negatively impacts the children, and it impacts them emotionally, it impacts them mentally, it impacts them in terms of their ability to become competent adults, to be good students. It impacts them in all kinds of ways. And so, if you want your children to be the best they can be, it is to their advantage that you avoid or limit as much as possible the conflict that may arise between the two parents. It's been suggested that uh, the children uh, the children are a composite of their parents, that there's a part of each parent in your children. And if you seek to have your children hate or dislike the other parent, then to some extent, that means they're hating or disliking a part of themselves. And that's a very uncomfortable and unhealthy way for children to have to view the world if they can avoid it. So wherever possible, take the high road, make concessions, and consider, is this really worth fighting over? Is this something that's going to create conflict and harm my children that I'd rather avoid? Can I make a concession? And also keep in mind that when you are divorced, there are going to be times where things are going to go differently for you than the way they are in the parenting plan. You may need the other parent to step in and take the children because you can't during what would ordinarily be your parenting time. You're going to need their help and they're going to need yours. So making concessions can work to your benefit because it's not always going to be a situation where you're following that plan to the exact letter, even though that might be your preference. There are going to be times where you need the other parent to step in and help you. And so taking the high road makes that easier to ask for those kinds of concessions and favors. Document everything. So we talk about this because we get in situations where you may be looking to modify the plan because for whatever reason, the relationship isn't working, the parenting plan isn't working, or you feel the other parent isn't following the plan. And you may need to demonstrate that to the court if you're going to ask for changes, and document your communications is going to be helpful for proving to the court why the plan isn't working and whose fault it is if that's the approach you're taking. So save, preserve communications, texts, emails that may be helpful to your cause in proving what has happened, what has occurred, so that the judge can view that and make an objective decision based on the evidence about what has occurred. Also, keep in mind that notes taken contemporaneously with or immediately after an event can be admitted as evidence to support your version of what occurred. But if you don't take those notes contemporaneously or immediately after the event, and then you're not going to be able to use that evidence, and your memories can be flawed. So some takeaways here: no matter what, you want to do what's in the best interest of the children if you can. And at this point, I would say let's take a pause and take some questions if possible.
Great. Thank you so much, Peter. All right, we have a few questions. If anybody else has any more questions, go ahead and get those in that Q&A at the bottom of your Zoom screen. But to start, here's the first one. What can I do if my co-parent continues to avoid the approved parenting plan and changes parenting time within 48 hours, also humiliating and bullying me in the process?
So first and foremost, you always want to look to the plan and see, does the plan specify any remedies in the event of a breach? So some plans have provisions that say, hey, if there's a breach or violation of the plan, the prevailing party can get his or her attorney's fees and costs for enforcing. Generally, there are two or three ways to enforce a plan. One way is that you can file a motion to hold the other party in contempt, but that tends to be somewhat of a blunt instrument. It tends to involve filing a motion, swearing under oath that the other party has violated the plan, which is, if approved by the court, is a court order. And then the court has to review your motion, decide, have you made a sufficient case for, if everything you've sworn to is true, is that a violation of the court order, or could it be? And then the court issues what's called a show cause order that has to be served personally on the other parent. Then they have to come to court by a date certain in that show cause order, be read their rights, and then return on another day for a hearing at which you'd have to prove that they violated the court order. So that's one particular approach. There can be other aspects of statutes that allow you to move to enforce the parenting plan or enforce makeup time if you're deprived of makeup time. So it depends on what the violation is. So I'd say those are, and then a third approach could be moving to modify the plan overall if there are consistent violations. But under the statutes, each of those has limitations, and there are pros and cons to taking the approach. So as I discussed before, document the violation so you have records of it. Document to see also how frequently it's occurring, whether it's substantial enough to warrant taking legal action. If somebody's harassing you, look to the plan to see, does it limit how and when communication are to occur? Because on the one hand, there may be provisions in the plan that say that restrict, for example, communications to a particular method, such as talking parents. And also keep in mind that if there's joint decision making, the parties have to communicate about those decisions. But you want to look to see, is there something that says, hey, if you have a joint decision to make and it's a major decision, this is how it'll be handled. There'll be a proposal of a decision, and the other party has to respond by a certain means within a certain period of time, or the other party is authorized to make the decision. What does the plan say? And those are factors that need to be considered. And then is it worth fighting over? Is it something that is worth bringing to the attention of the court? Those are considerations, and there's no clear-cut answer. It's something that has to be decided on a case-by-case basis.
Thank you so much. Okay, related to that, along with enforcing the parenting plan, if someone is continually violating the parenting agreement, is there any action specifically that I can take beforehand so my children don't miss out on their agreed upon activities?
Boy, that's a tough one because what I always say is, look, the only behavior that you can control is your own. You don't control the other person's behavior. And there's always a risk that if you approach the other party in a way that offends them, that can lead to more conflict rather than less conflict. On the other hand, if you have a specific enough parenting plan or agreement, um, you may need to uh, point out to them what the plan requires, that there's a specific provision that addresses parenting time, and that you need them to work with you to comply with those aspects of the plan, document that you've requested them to comply with those aspects of the plan, and then if they don't, consider what your legal options are, because again, you can't control their behavior, but the court can take action to enforce, punish, award makeup time. Um, and so that's why we've talked about why if you can compromise, if you can propose alternative solutions, if you can consider that the other party is going to need concessions from you at times, and maybe there's an opportunity that you can make a concession here, but ask for something in return, propose alternatives. That may be the best approach or a better approach than going to the court for intervention.
All right, Peter. Well, that is our last question for this evening. Any final words before we wrap up and sign off?
I would just say this is one of the more difficult areas that can be problematic for parties, to the extent that you can confer in a non-threatening fashion with the opposing party, or the other parent, about solutions, alternatives, ways to resolve disputes. That's a good thing. But there are going to be times where you may not feel safe communicating with them directly. That's where you may want to consider having counsel do it for you. You may want to consider limiting the approach for communication. That is through, say, hey, it's not going to be by phone, it's going to be by text, but always be wary that communicating by phone or text can cause nuances, tone to be learned, lost, or misunderstood. So if you can communicate by phone and you have that kind of relationship where you can do that, that may be an opportunity to avoid misunderstandings. But if tensions run high, that may not be an alternative for you. So just be thinking about alternatives means of communicating. What's the best approach for communicating over this particular issue? Uh, what is the safest approach? And do I need someone to serve as an intermediary or to speak for me? Because there may be times where you say, look, I don't want to appear like I'm not cooperative, and I don't want to appear like I'm unable to make decisions together with the other parent. But if the tensions are so high, or there's so much conflict, or there's safety issues involved such that I need to have somebody else speak for me, that's something that you may want to consider. And that's where you might want to have counsel involved.
Great. Well, thank you so much, Peter, and thank all of you for attending tonight. As a thank you for attending, we would like to offer you a free consultation. As Peter mentioned a couple times, every case is different, and we really want to help you specifically with yours. If you have specific questions about your case, we'll offer you a free consultation to meet with one of our attorneys. Just give us a call and give them the code Wiser Together when scheduling. We also hope to see you at another Wiser Together webinar. We wish you peace, and we hope you have an excellent Wednesday, everybody.